All right. Hello, everybody. Welcome to the Litigators Network. This is a podcast where we get to talk about different areas of law, areas that are not just interesting to us as lawyers, but that apply to us in our practice. This is geared for those, for everybody, first and second year attorneys that are dealing with these issues as a first impression. It's also geared for the seasoned attorneys who may have dealt with some issues in the past and now are seeing these pop up once again. And for any students that are interested in the law, this is the place for you to be. So welcome, and we're going to get started today. I'm very excited for the topic that we have today. We have an amazing attorney who has a particular background that's perfect for this sort of topic. We're going to be talking about the Fifth Amendment, but I'm going to give some space first and introduce our amazing guest. We have James Perry with us. James, thank you so much for being here today.
It's my pleasure. I've been looking forward to this, and it's always great, great seeing you.
Yeah. So James, why don't you introduce yourself a little bit? We are going to be talking about the Fifth Amendment. So give us some background as to that as well, because you have a particular sort of background and experience that is very unique that you bring to the civil world.
Sure, absolutely. So, fresh out of Berkeley Law, I went directly to the prosecutor's office, really. And so I spent roughly the first 10 years of my career in the law as a prosecutor, and the vast majority of that time with the Los Angeles County District Attorney's Office. And really, before I left the last couple of years, I was really dealing with homicide-related cases, and particularly in the gang context, involving complex conspiracies and other really complicated cases. And of course, as you can imagine, the Fifth Amendment comes up quite frequently on the criminal side. And then, of course, a few years back, I transitioned over to the civil side.
Yeah. One thing that I find very you have many things in your career that you've done that are amazing. But one thing I did note in sort of reading up about you a little bit more is that I know that you're a coach for the trial team at your alma mater, right? So can you talk to us a little bit about that and why you do that?
Yeah. So honestly, trial advocacy is, I think a lot of people think of trial advocacy as a profession or as work. Really, the only reason I went to law school in the first place was because I did undergraduate mock trial. And it's actually kind of funny. Initially, I didn't even know really what trial work was, but I just knew that I loved what I was doing. And so I was like, all right, I have to go to law school. Continue to do trial advocacy in law school. Loved it. Obviously, that's one of the reasons I went to the DA's office. But because I love it so much, one of the big things for me, and one of the things that I really enjoy doing is giving back, and particularly to the students at my alma mater. And so it's a passion. It's something that I really enjoy.
Yeah. It's something that we share, because I often go back and help judge trial competitions. I went to Loyola Law, and I'm very connected with that. So it was a great time for me in law school, and certainly it's always great to give back. So definitely commend you for that. All right, so let's get going then. So the scenario here is that we are looking at defendants' discovery responses, and we run into a specific objection, right? They're invoking the Fifth Amendment, and they're refusing to provide any responses. And so for attorneys dealing with this in their practice, I think the first thing that we need to know is, what is the Fifth Amendment exactly, and when does it apply? So I'll throw that right over to you, the authority here.
Yeah. So, just briefly before I get into it, I have to say that the first time I saw discovery responses with an objection on Fifth Amendment grounds on the civil side was one of my favorite days, because, shortly after transitioning to the civil side, I was like, man, there's a lot of new stuff going on. But then I see this Fifth Amendment objection. And of course, my first thought is, all right, here we go. Here's my wheelhouse. I finally know what's going on here. So the Fifth Amendment is, unfortunately, we don't have a lot of reasons to dive into the Fifth Amendment like we do on the criminal side. But the Fifth Amendment is not it really is an overutilized objection on the defense side. And the reason for that is because there's really three specific elements that really must be established when you're dealing with the Fifth Amendment objection. The first
Mhm.
is that the whatever's being requested has to be compelled from
Mm.
the other side. The majority of courts find that the legal process itself is obviously a form of compulsion that's sufficient to trigger the Fifth Amendment. Okay, fine. It's really the two other areas that are really kind of problematic for the defense, but a lot of plaintiffs' attorneys and a lot of attorneys, generally speaking, don't realize that. And those other
Mm.
two elements are that the material that's being requested has to be incriminating, and then
Okay.
it has to be testimonial. And so incriminating is pretty self-explanatory, but testimonial, just to touch on it,
Mhm.
testimonial means that you're essentially it's something that is within the thought process, something that is sort of within the mind of the person that you are compelling the information from.
Mm.
And a great example that I like to give is material that is ultimately turned over by the prosecution to the defendant in the criminal case. So when we think about, right, what is incriminating, certainly material that's turned over by the prosecution to your defendant, who was also a criminal defendant in the simultaneous criminal trial, it's not possible for it to be incriminating for the simple reason that production of that material to you in the in the civil case cannot further the prosecution of the defendant in the criminal case,
Mm.
right? Prosecution already has it. And so, and going to the second element, which is the testimonial component,
Mhm.
you're not you're not forcing anything from the mind of the defendant. Again, it goes back to the fact that the prosecution gave it to the defendant, who is then turning it over to you. And
Mm.
so, and this has been recognized by the courts. In fact, the Central District, the Chief Judge Gutierrez, I believe, actually wrote an unpublished opinion on this, saying exactly that. Fifth Amendment
Yeah.
is not implicated when you merely turn over discovery that was given to you by the prosecution.
Yeah, and it's so interesting because it happens many times where there's that civil case and the companion criminal case, and you're trying to get information, and they simply say, "Well, no, it's related to the criminal case, so you can't." And I think early on in your career, in an attorney's career, you might think, "Well, yeah, that makes sense." But what you're saying is that actually quite legally and almost logically also doesn't make sense. Actually, you should have access to it, especially if the prosecutor has it. So how do you get access to that information? Is it simply like you send out your discovery request and defendant has to produce whatever the prosecution has produced over to them? Or, how do you go about that?
Yeah, so that really is probably one of the most important questions is how to go about it. And so there's to break it down a bit is first really it's the way in which you frame your questions, whether that's and I'll refer to an RFP, because that's typically how we get the most of our documents that we really want, we're going to rely upon. And so it's when
And
you're
just to
framing.
clarify for everybody, RFP, a request for production of documents. That's a tool that attorneys use to get their information, documents from the other side.
Yeah, definitely. And so right in especially at the beginning of the case, that's one of the biggest tools we use. And so it's really framing those requests in a way that, to start with, avoids a Fifth Amendment issue. And the reason I make that point is because there is case law out there, published case law, where the requests, for example, were framed in terms of give us everything related to a criminal event. In other words, the
Mhm.
request was actually asking for incriminating material. And so when you frame your request that way, you are naturally going to draw not only a Fifth Amendment objection, but you might lose a court
Right.
on your motion to compel. And so when you're framing your requests, frame it in a matter where you're going to get incriminating information, but you're not specifically asking for incriminating information. So in other
Mhm.
words, right, if you have a racketeering case or some sort of fraud case, you're not asking for all evidence related to the fraud. you're asking for all evidence related to any activity surrounding X, Y, and Z event.
There you go.
And so that's that's kind of the first step, is making sure you're framing it away from language that asks for incriminating material, but that includes it. The second is when you ultimately get the responses back. You have to keep in mind, and this goes really to the breadth of 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 what you're entitled to, and how sort of minimal the impact of the Fifth Amendment is on the civil side. And so,
Right.
one of my favorite ones to address with opposing counsel is, please explain to me how the Fifth Amendment applies to anything supporting your defenses in the criminal case or in my case, right?
Mm.
Because if it's supporting your defenses, it certainly can't be incriminating, right? Because that's your defense.
Using it. Yeah.
And so that's usually one of my sort of favorite conversations to have. But then there's also this sort of spectrum of other material that just really has nothing to do with it. Insurance information, um, you know, uh, uh, communications before a particular event arose, or maybe something that's unrelated to the event itself.
Mhm.
There simply is just there's it's highly unlikely that it's going to raise an incriminating objection. But also, really on this point too, keep in mind that the mere fact of the defendant turning something over to you or producing something to you doesn't actually pull any information from the defendant's mind. It's a little complicated, and I won't dive too much into it, but there's actually very limited circumstances where the testimonial element can actually be met on,
Mm.
for Fifth Amendment objection.
Interesting. Okay. And that kind of part of what you're kind of getting to here that I wanted to ask is, when the Fifth Amendment privilege is invoked, many times we attorneys, or just civilians, sort of think of it as being this general sort of blanket invocation, right? And what you're saying is that it's not. And so how do we as attorneys, plaintiff attorneys, then go about you know uh, getting from the defendant, because what you're saying is that they need to provide specific sort of objections, right, to specific questions rather, and they need to provide detailed information as to why that objection or that privilege applies. And so how do we go about that, one? And then two, what's the benefit of kind of narrowing down the reasons behind their objection and their invocation of that privilege?
Sure. And yeah, so this really it all really flows together about how you frame your requests, and you want to make it maybe narrow for certain reasons. But
Mhm.
the reason all of this sort of meshes together is, it's a California case referred to as Warford, or called Warford.
Mhm.
And what Warford says is that there's no such thing as a blanket Fifth Amendment objection. In other words, you can't just say Fifth Amendment and just, you know, select and drag
You don't
that
have to say
that
anything else.
response to the page. Yeah, you can't do that. And the
Mhm.
reason being is that it all starts with the fact that it's the court, not the defendant or his counsel or her counsel, that makes the determination as to whether or not the Fifth Amendment applies.
Mhm.
And so, because it's the court that has to make that determination, the court has to be given some basis for making that determination. And so, what Warford says is that you have to make an objection as to a specific question or a specific topic or a specific category of material, and you have to give a plausible explanation. You don't have to disclose necessarily what may be protected by Fifth Amendment grounds, but you have to give the court some nexus to work with to understand how it's even possible that the Fifth Amendment applies. And so
Mhm.
that's always an area I push back on as well. And I'll cite the Warford case, and I'll tell them is like, you, right now, just your objections alone are insufficient. I can prevail on a motion to compel just based upon this objection alone.
Mhm. Yeah. All right, cool. So it's really important to understand and to know, because yeah, I mean, we hear the Fifth Amendment and we just think that you don't have to the defendant doesn't have to say anything else, and that's it, because that's what we see in movies. That's what we're led to believe, but that's not really the case here. And so when a Fifth Amendment uh, when the Fifth Amendment is invoked, many times there's that obviously we're talking about a civil case and a criminal companion case to it, defendants often ask for a stay, right? Meaning they want the civil case to sort of pause and, nothing else is done on the civil case while the criminal case goes on. Many times plaintiff attorneys will just kind of say, that makes sense, right? So I guess we'll just let the stay be implemented. Is that something that you would agree with? I mean, certainly I would imagine that it depends on a case-by-case basis, but generally speaking, are there tools that plaintiff attorneys can use to sort of go against that? Do the defendants have a right to a stay? How does that work?
Sure. And so it, the question of whether a stay is appropriate in the case, as you indicated, is oftentimes really kind of a case by case determination. But for the most part, there's really your two camps. There's the camp where the civil case revolves completely around the civil case, or excuse me, the criminal case, and it's very difficult to distinguish between where the civil case ends or the criminal case ends and the civil case begins. And a great example of that is I have a wrongful death case where the individual that actually it was a motor vehicle case where the individual was driving and hit some children on the side of the road. And the biggest issue in the case is we obviously have to hear from the driver. Right, there's government entities that have been brought into the case that are defendants in the case. There's the bus company, but the problem is that we have to hear from the driver.
Yeah, of course.
And so, and then you have your other camp. You have your other camp, whereas I had this, I still have this sexual assault case involving Lyft, and there was a motion to stay in that particular case, and I'll kind of talk about that one first. And the motion to stay in that case, we fought because the criminal case had very little to do with our case against Lyft. And the case against Lyft was a rather substantial part of it because our whole position was that Lyft was not doing enough to protect these victims, to protect these people that were coming into the car. So we wanted to dive into discovery regarding Lyft that really had sort of little impact on or little relationship to the criminal case itself. And so there was a lot that could be done without staying the case. And so in these sort of two camps where you can do stuff without staying, and then there's another case where, it kind of looks like a stay might be appropriate. A lot of it comes down to, the question of fairness. And to go back to your original question, a defendant absolutely does not have a right to a stay when there's a simultaneous criminal case. And the California Supreme Court has made this abundantly clear. And this opinion is still cited regularly. And it recognizes is that, no, we can walk and chew gum at the same time. And a defendant doesn't benefit simply because, he or she also picked up this criminal case. And so the notion is that under what's referred to as the Keating test or the Keating factors, is the courts take into a lot of consideration all of these sort of this universe of information. And it's everything from what prejudice will plaintiffs suffer? Is there are there other individuals that we can't hear from because of this criminal case, or how much can be done without a stay? And so the California courts have made clear is that the court really needs to go out of its way to find a workable solution, and that a stay really is a last resort. And so in our in the bus case, we agreed upon a short stay because we absolutely had to get information from this person. Whereas on the Lyft case, we fought it because our whole thing is that, no, we're good. We have this guy's prior admissions. I don't really care if I get a deposition from him. I have all this testimony or prior testimony from him. I just want to go after Lyft. So
right. I don't mean to put you on the spot here, but given your history as a prosecutor and now in the civil arena, have you seen any of these sort of solutions or interesting sort of solutions that judges have created in terms of the Fifth Amendment and sort of allowing a case to proceed, but maybe special circumstances, some unique sort of solutions from that end?
Yeah. In fact, actually, we have this oil production case where it's an environmental case. The facility emitted all of these nasty chemicals into the surrounding community, and the two owners of the operation company, they specifically they've been fighting us nonstop to get their depositions on Fifth Amendment grounds, and it's been motion after motion after motion. And so what the court has done is, in this particular case, the court's solution is, because we're pretty late in discovery, and so the court's solution is that, okay, fine, I will stay the depositions of these two individuals up to a particular point in time. So in other words, it wasn't a complete stay of the case. He made this order that he was going to stay the deposition of these two individuals while we continue discovery kind of surrounding their depositions. And this is actually consistent with case law too. Courts have said that, fine, the solution can be, we'll give you a date by which you need to provide a deposition. And if you don't provide a deposition by this period of time, you get to face the consequences of invoking the Fifth Amendment, which is what happened in this oil production case. And we're still actually in the middle, and we're waiting for that period of time. And it's important to note that, a lot of people think that there's a lot of defendants, unfortunately, think that there's this constitutional right to avoid the consequences of invoking your Fifth Amendment right on the civil side. And that is absolutely not true. Yeah.
No, thanks for sharing that. I love that. And it's one of these situations with you run up into this with clients a lot where they ask, wow, you can negotiate that, or I didn't know you could do that. It's like, listen, everything's negotiable. Now there are rules, there is cases, there are laws, but really there's so much that you can do still within the framework of the law, right? And what you're telling us here is, hey, even if you're dealing with a situation where the defendant has invoked the Fifth Amendment, it doesn't mean your case has to be put on pause indefinitely. You can still continue moving forward. You can still get what you want, and there can still be creative solutions to going about your case without having to put an absolute pause on all of litigation. So that's great. You mentioned consequences. I was wondering if you could expand on this a little bit more. You said that many times defendants think that they can just invoke the Fifth and not have to deal with the consequences of it. What are the consequences of invoking the Fifth Amendment that plaintiffs, attorneys and plaintiffs can use? Because, one thing that I've heard you say in the past is that you think that even a protective order being instituted in a case where it is seen as something negative, right, in this case for plaintiffs, can actually be used to your advantage. So can you talk to us a little bit about what are those consequences that we as plaintiffs attorneys and plaintiffs can use?
Sure. This is sort of one of the aspects of the intersection of Fifth Amendment and civil law that I love the most, and I wish our colleagues really would utilize this more often. And so, to kind of backtrack, as I just said, California courts have made abundantly clear there is no constitutional right to avoid the consequences of invoking your Fifth Amendment right in the civil context. And to be clear, you have a right to invoke the Fifth Amendment, but you face the consequences of your actions. And this is both in California and in Ninth Circuit law. This is what these courts say. And so what that means is that the courts will work with a defendant to find a workable solution. And so maybe that's a protective order. And so what I tell our colleagues is that a protective order just delays the inevitable, which is that at some point the defense is going to be put to the question of whether they stand on the Fifth Amendment right or they face the consequences. And what I mean by the consequences is that it's the same as sort of any civil discovery issue, is that if you don't get the material that you want, that falls within, whether it's 2017.010, which is sort of that kind of that statute that allows us to go after material that reasonably can be connected to the case. If they don't give you that material, for example, by a particular date, or the defense doesn't give you a deposition by a particular date, you're entitled to bring a motion for sanctions based upon a failure to comply with the discovery obligation. And the failure to comply with the discovery obligation is no different than if it had nothing to do with the Fifth Amendment and the defense was just being obstreperous or trying to hide highly critical evidence. In other words, you can seek everything from evidence sanctions issue sanctions, right? Monetary sanctions, and for on a deposition side, possibly even that the defendant can't testify in your trial. A lot of it really depends upon the circumstances of the case. And so, in other words, if the court has made an effort to work with the defense to essentially accommodate the defense's rock in the hard place, but the defense still doesn't comply, it opens these doors. Now, be mindful the information that you're looking for example, defendant's deposition, that is critical to the case. You need that, right? You need to hear from the defendant. And so you're probably going to open up those sanctions a bit more than if you're seeking evidence that, possibly could be attained from, one of these other figures that are sort of floating around on the boundaries of your case. So it's a need-based question, I think. It's also a question of, is there prejudice? How much prejudice to you, to your client? And so if you start kind of factoring in these aspects of your case, and I try to focus on things that I know are critical, that I know are in the defense's possession, because I want to make them uncomfortable. That's my goal.
Of course. That's awesome. All right. Well, James, I think we're kind of running into our the end of our time here together. But before we let you go, can I ask any additional last sort of tips that you'd give to our fellow litigators, plaintiff attorneys, and maybe trying to get some discovery when the Fifth Amendment comes up, or anything maybe that we haven't touched here?
Yeah, I mean, other than to read the article that I wrote, I would say that
where can they find it? Where can they find it?
Yes, it's actually in the Advocate, and I believe it's October of 2023, if I'm not mistaken. But take a look at it, and certainly reach out. But the tip that I would give is don't believe that the Fifth Amendment applies simply because it's invoked. In fact, to the contrary, the vast majority of material that's going to be objected to has no business being objected to. And so push back, find some case law that, that specifically says, no, you don't get to invoke it, and start to make them feel uncomfortable. Think about whether you need that stay, or whether there's a benefit to, to start to make them squirm, start to make them think about the case. Does it help with negotiations, settlement negotiations? Does it help, open other doors? That would be the advice I give.
Awesome. All right. Well, James, thank you so much again for your time. This is great. It's one of these where I'm going to listen back to this while I'm working out or doing something, right? And thank you for providing this. This is great information. And yeah, if anybody's interested in this or wanting to talk to James a little bit more, I know James is more than willing to chat. So feel free to reach out. He's a great attorney that we have. He's part of the board of the Inland Empire, California CAOIE. Consumer Attorneys of the Inland Empire, and I'm on the board as well. But he's a great attorney, works at Axe Law, and he's a great contact to have. So definitely reach out. Again, James, thanks for your time with us. Thanks for spending your evening after a long deposition session, all-day deposition session. You still made it for this, so thank you very much for your time. And to everybody else, we will see you on the next episode.